Hello and welcome to Health Affairs This Week. I am your host, Jeff Byers, and happy Dismemberment Plan reunion weekend to all that celebrate. Today we will be talking about non-compete agreements. But before we begin, we released a new issue this week. Check out the table of contents in the show notes and order a copy if you feel so inclined. Also, we released a new health policy brief. Health policy briefs seek to make hard-to-parse healthcare concepts more understandable. The new brief is titled Direct Democracy and Population Health, Making Health Policy Through State Ballot Initiatives. Check it out in the show notes. Today in the show, I'm joined by our very own Chris Fleming. Chris, welcome back.
Good to be back, and I'm not sure I want to know what dismemberment reunion means, but maybe I'll find out at some point.
Yeah, you're in DC. You should know. You'll know. You know, I'm sure there'll be a lot of people with TI-83s walking around K Street that will be able to help you out.
I don't know. Just having streamed belatedly the series Dexter, dismemberment has sinister suggestions. So hopefully it'll be better than that.
Undoubtedly. Chris, today we're talking about non-compete agreements and the supposed ban. Can you give us a little update quickly on the news of that?
Well, sure. So the background of this is that the FTC a while back proposed to ban non-compete agreements, or non-competes as they're sometimes called, and then they finalized that rule earlier this year. And these are just sort of what they sound like. They're agreements that employees sign with their employer that says if they leave their job, they're not allowed to take another job that competes with the employer or start a business that competes with the employer, usually within a set geographic area or, and also within, sort of a set period of time. They loom large in the economy in general. I think estimates from the FTC and others are that 1 in 5 workers are affected by these non-competes. So they're broader than healthcare. But, for our purposes, obviously, we care most about the effect in healthcare, and they're a huge factor in that industry.
Yeah. Before we jump into non-competes in the healthcare industry, so there was supposed to be a ban on non-compete agreements that were supposed to go into effect September 4th. Is that correct?
It was. And of course, living in the world that we do now, as soon as the rule was finalized, the next day, there was litigation. The Chamber of Commerce and others jumped into court. And in one of those cases, a federal judge in Texas last month issued a injunction blocking the imposition of the rule, not just for the plaintiffs in that case, but nationwide. And that this is sort of a whole issue in and of itself, that one judge, can issue a nationwide injunction that blocks something, not just for the plaintiffs, not just in his or her jurisdiction, but nationwide. But that's what happened. So nothing is, we are recording now, I guess, on the 5th, and nothing went into effect on the 4th.
Okay. Yeah. So thanks for that. So let's go back to that context of the healthcare system. How do non-compete agreements affect the healthcare system?
Well, for instance, there are estimates that somewhere in the 30-something% up to half, nearly half of physicians are affected by non-competes. And that's probably getting, that number has been climbing because you have you have this vertical consolidation. Physician practices have been acquired by, hospitals, health systems, corporate entities, private equity entities, and that increases the number of physicians that get potentially subjected to these. They can also affect nurses. I've seen estimates that maybe a quarter of nurses can be affected. Now these are, and they have all sorts of impacts. They can depress wages in healthcare and other industries. They can increase or they could increase consolidation, because if we were just talking about the corporate entities, private equity. They could lock up physicians through these agreements and build these large systems. And then that in turn actually can make the non-competes more onerous for the people, the physicians, nurses, others who are subjected to them, because these entities can be quite large. And instead of maybe, a couple of miles, 5 or 10 miles, you suddenly find yourself, not allowed to take another job, in a couple of states or something like that. And this can have effects on innovation. People have looked at sort of as states have adopted greater or lesser restrictions on these non-competes, what's happened in terms of number of patents that get issued. So there's a whole range of effects in healthcare as in other industries.
This is something I know that Brent Fulton, through our Health Affairs Insider program, has talked about in his newsletter about antitrust and competition. Chris, in your research for this episode, did you get a sense of, do potential employees know that these agreements exist or what they're actually signing?
That's an important question. I should mention very quickly before we move on that there are estimates that you could end up close to a couple $100 billion in extra costs. So that's one effect that I should have mentioned, direct effect in terms of healthcare from non-competes could add hundreds of billions of dollars to healthcare costs. I also want to mention, you mentioned Brent Fulton. We had a piece on Health Affairs Forefront by Aaron Fuse-Brown, Mega Reddy, and Chris Whaley that did a wonderful job of talking about sort of what the FTC rule said, the effects of non-competes, and the legal challenges, which we talked about briefly, and I know we'll get into. And as you said, part of the problem with these is that often you take a job and then you walk in on day one and they say, hey, there's a non-compete agreement we'd like you to sign, and you've already left your current job. So you're kind of, like either you sign, or if you don't sign, then what do you do? Because you have no old job to go back to.
It is not a great choice.
It is not. And there have been, I think Brent mentioned, one possibility. I mean, the FTC, of course, sought to ban most of them, and we'll get into hopefully, what most of them means, because there's some limitations in terms of reaching or not reaching nonprofits and senior executives. But one step that could be taken short of that would be to say, before you take a job, the employer has to disclose that they're going to ask you to a non-compete agreement.
Okay, so with that, so what happened with the ban? So you already did mention what happened with the ban, but is the ban dead in the water?
Well, so far now, the court decisions, they're really important for the fact that the one in Texas actually blocked the imposition of the rule completely, and there are a couple other ones I'll mention, but they're also important because of what they say about what is going to happen in terms of healthcare regulation going forward. Specifically, the court in Texas, the judge mentioned the Loper-Bright case, which the Supreme Court just handed down this previous term. What that did is it got rid of something called Chevron deference, and it sounds a little nerdy, but what that meant was that courts would defer to agencies if the agency if there was some ambiguity in the statute and the agency interpretation was reasonable. Courts would say, okay, the agencies have the expertise, we're going to defer to them. In Loper-Bright, the Supreme Court said, no, you shouldn't do that. It's up to the court to decide what the law means. And a lot of people said that's going to make it much harder, or much easier for courts to strike down attempts to regulate in healthcare and other areas. And this is, perhaps sort of a canary in the coal mine, an early indicator of that. The Loper-Bright was cited and the court blocked the rule. There was also a case that came out of Florida, on the federal court in Florida. The immediate effect was less dramatic. They issued what's called a preliminary injunction, which means it's just sort of an intermediate step as the case is proceeding through the court. And they blocked the imposition of the rule just for the plaintiffs in that case. But the judge in that case cited something called the major question doctrine, which comes out of a Supreme Court case, West Virginia versus EPA. And what that says is when agency seeks to regulate in an area of vast political and economic significance, you really have to have an absolutely clear authorization by Congress that they can do this. And again, when that happened, it was seen as this particular Supreme Court has been particularly hostile to the administrative state. This was seen as another attempt to limit the power of agencies. And so the fact that the judge not only cited this in the Florida decision, but he also, if I recall, he essentially said that the plaintiffs might have lost were it not for this new doctrine. That again says that the agencies are going to have a hard slog going forward. So, as I said, for now, things are blocked. There'll obviously be appeals. The FTC is probably going to appeal the decision in Texas, and then there'll be appeals in the other jurisdictions that'll make their way up through the different circuits. There was a court in Pennsylvania which actually upheld the rule. So you may end up with what's called a circuit split, where different federal appellate courts come out with different decisions, and ultimately the Supreme Court may well weigh in. Of course, the Supreme Court, as we were just talking about, has been pretty hostile towards the agencies and rulemaking. So if you had to bet, you probably would not bet on the FTC in this case. But you never know, and we could talk as well. There are state remedies that may come into play, other federal agencies. There are a lot of other sort of things to watch going forward on this.
Yeah, so like in the fourth quarter on any given Sunday, anything can happen is what you're saying.
Yeah, I mean, for instance, the states have traditionally regulated these agreements. There are 4 states that ban them entirely. There are another, I think, 11 states and D.C. that ban them for all or some workers in healthcare. There are like 36 states total that have some restrictions. So going forward, particularly if the FTC ban is blocked, the states could be, a huge area to watch. Even if the ban is upheld, ultimately, what the FTC ban is what they call, it's a floor, not a ceiling, which means it doesn't preempt state laws that are more restrictive than the FTC ban. So states could fill in the gaps. For instance, the FTC power does not reach nonprofit institutions. And obviously in healthcare, nonprofit hospitals are a huge factor. I mean, most institutions are nonprofit. Most hospital workers work in nonprofits. So the states could fill in that gap. Now, the FTC has suggested it could potentially reach some nonprofit hospitals because they said they would go after if you were tax exempt, but if you were essentially acting as a profit-seeking enterprise, they would go after them, but that would be on a case-by-case basis. The states could fill that gap. There's also an exemption for what they call senior executives, where if you make more than, I think it's 150,000 and you set policy, you can't, those non-competes for those 8, you can't have new non-competes, but those are not voided like non-competes for other workers. The states could be more restrictive on that front. You could have other federal agencies. The National Labor Relations Board could jump in. It issued a general counsel memorandum suggesting that it viewed non-competes as an unfair labor practice. So there are a lot of different, even if the FTC rule ends up being blocked between the states, and Congress is another place to watch. There's some bipartisan legislation there, although it hasn't advanced. Although these days, just the fact that there's bipartisan anything is significant. So we'll see. I mean, there's a lot of, like you said, it's the, I'm a New York Mets fan, so I well know, much to my regret most of the time, that anything can happen. So I remember being seven games up with 17 to play, and it didn't mean a damn thing at the end. So who knows what will happen?
And who can forget the, I want to say 63-point lead
from
the Falcons and the Patriots, but I don't think that was
it wasn't 28 or something like that.
27 maybe?
Yeah.
Do you know?
All they had to do was they could have just fallen on the dang ball.
Lifetime ago.
Never mind.
Well, as we come to a close, I think that covered a lot of what we prepared to talk about. Is there anything else regarding non-competes and the future state of potentially these agreements?
Well, I mean, I think, we talked about the way that this could be part of sort of this emerging legal landscape that could affect the agencies in a lot of different areas, not just non-competes. I think an interesting part of this sort of whole picture of healthcare consolidation. There's been huge concern about the sort of gobbling up of healthcare institutions by corporations, private equity, and this is sort of, is part and parcel of that. It plays into that, so that it's an important topic. The non-competes, obviously, just in and of themselves, but they're also sort of part of a lot of interesting trends in a lot of different ways that bear watching.
Well, Chris Fleming, thanks for joining us today again. I was able to get some football references and a dismemberment plan reference in, so that's great for me. If you, the listener, enjoyed this episode, please send it to the New England Patriots fan in your life, and please have them subscribe.
Thanks a lot. Enjoyed it.
See you next week. Thanks, Chris.